Hi, my name is Michelle and I am back with another video. I really enjoy recording Q&A, question and answer videos, because it gives me the opportunity to respond to specific questions from those of you who follow me here on this YouTube channel, or you follow me on Facebook as a member of my Facebook group. By the way, if you aren't a member, I'd like to invite you to join my Facebook group. It's called Notaries for Alabama Hangout. It's a free Facebook group for anyone who is a commissioned Alabama notary, or if you are an Alabama resident and you are seriously interested in becoming an Alabama commissioned notary. You will find it very helpful and educational for you to network with notaries from all over the state. I'll be sure to include a link to the Facebook group in this video description, and I'll also post it in the comments below. And if you've been watching some of my other videos here on this channel and enjoy them, learn from them, see value in them, I want to ask you to take just a few seconds to click the subscribe button or the like button. It does make a difference for me and definitely to the channel. Now, in today's video, I will be answering the question, when should notaries refuse to notarize? I hope you'll stick around and join me and listen. Let's go ahead and read the question together. This came from someone here on YouTube, and she writes, "Can you give me different scenarios of why you have to refuse to notarize someone's signature? My husband just became a notary and hasn't done anything yet." So this viewer was responding to a short I posted a while back where I stated that one of the most difficult parts or aspects of being a notary public is when I have to refuse to notarize someone's signature. I have to turn away their request. And M. Garciber is asking for a little more detail, and I will gladly answer. So yes, there are times when notaries are required to refuse to perform a notarization. And for Alabama notaries, your husband and notaries in general can find this information, some of it at least, in Alabama's new notary law that went into effect September 1, 2023. I came up with the name Alabama's Notary Accountability Act of 2023. In that document, it clearly states that Alabama notaries are subject to having criminal charges filed against them if they either do something that they shouldn't be doing or they fail to do something they should be doing when using the title and official seal of notary public. And the law that went into effect last year makes it a lot easier for Class C misdemeanor charges to be filed against a notary, and for Class D felony charges to be filed against a notary public. I will provide you with more information about the notary law a little later in this video. So make sure you stay tuned. All right, the number one reason for a notary in Alabama, and to be honest, in any state, to refuse to notarize a person's signature is when the signer, the customer, the client, the person wanting their signature notarized, does not appear before the notary in the flesh. Signers must physically appear before the notary. The only exception is remote notarization and power of attorney notarizations. Now, for some of you, you're thinking, well, this is a no-brainer. No, it's a little more than a no-brainer. It is not uncommon for, let's say, a spouse, I'll say for a woman to take a form to a notary that has already been signed by her husband, and then the wife says to the notary, hi, I need you to notarize my signature and my husband's signature. And then she'll hand the notary an ID for her, an ID for her husband. And she'll say he couldn't be here either due to sickness or his job or he's out of town. But she'll say to the notary, you know, you can call him. He'll tell you it's okay. He just had to leave right away out of town. And even though the wife is telling the truth, even though there is no fraud taking place, and so the wife doesn't see what the big deal is. They're married, you know, they're like one person. She feels she can speak on behalf of her husband. Even in that situation, notaries must refuse to notarize. I'll go a step further and say, even if the notary knows the wife and the husband very well, even if they're close friends, even if they're family members, the notary must not, cannot notarize the husband's signature in that example. And yes, even if the notary calls up the husband and says, hey, Frank, yeah, your wife is here with the form, says it's got to be done today. Did you sign it? Did you understand what you signed? That is still against the law. The notary must refuse. And that's what makes it so hard when we notarize for individuals that we know and are close to, which I think is one of the main reasons why Alabama recommends that its notaries not notarize the signature of immediate family members, close family members, because in those situations, we are tempted to bend the rules. So personal appearance, this is a very common, I don't even want to call it mistake. I'm going to call it an occurrence. This happens a lot. And a lot of notaries get in trouble about this occurrence, this type of scenario where they made an exception. They allowed themselves to be convinced that it was okay. And especially notaries who've never been trained, they don't understand this. So this is the number one example. Moving on to a second scenario. When the signer provides unsatisfactory identification. In the state of Alabama, notaries must identify signers in one of two ways. If we can personally know the signer, and that's sufficient. And if we don't personally know the signer, then we must request valid government issue ID. Okay? The new notary law goes into a little more detail, which is why I want you to take your time to go through the law and read it for yourself. The types of ID that I prefer: state driver's license, state ID, passports are just three of several IDs that are sufficient. Another part of that is it's the notary's job to make sure that the name on the ID corresponds with the name that's on the document that needs to be signed and notarized. So the other things I want to say about unsatisfactory ID, it's not as simple as requiring the notary to just, or requiring the signer to hand the notary the ID and the notary just glances at it. No. Notaries must study the ID, make sure the person appearing before them in the flesh looks like the photo on the ID, matches the physical description outlined on the ID, and also compares the signature on the ID to the signature that gets made on the form and also on the journal if the notary maintains a journal. I require all signers to remove their IDs from their wallet, because verifying someone's identity and making sure it's a valid ID, I need that ID in my hand so that I can make sure that it is a valid identification card. That's reason number 2 to decline. Going on to reason number 3. A reason to refuse to notarize involves the oath or affirmation. What do I mean by that? There are certain notarizations, in fact, a jurat notarization being one scenario, requires the notary to administer an oath or affirmation to the signer. If the signer doesn't comply or agree to be placed under oath, the notary must refuse to perform the notarization. Here's the kicker. Many Alabama notaries aren't familiar with what a jurat notarization is, what it looks like, nor do they know how to administer oaths. And so again, how can they then know when an oath is necessary if they don't know how to perform it? And so again, to be clear, as a notary, we should refuse to notarize. If the signer refuses to be placed under oath when an oath is mandatory or required. And the best way for notaries to understand when an oath is required is to get training so that they can be taught how to perform this type of ceremony. The next reason, I'm going to go back for a moment. Yeah, my numbers are off. Let me fix that quickly, because otherwise it'll continue to be off. Moving on to number 4, reason number 4 for when a notary should refuse to notarize, and that is if the signer is being forced or coerced to sign their name on the document. This happens more times than one would think. And it happens more likely from family members, not total strangers. It is the notary's responsibility to verify that the signer is acting and signing voluntarily. I'll say this just briefly. This has happened to me several times. And the one time that comes to mind, I was contacted by a woman's son, an adult son. If we weren't the same age, we were close in age, and he told me that his mother needed to change her will. And when I asked him, I ask a lot of questions when someone asks me to notarize for them. He told me that the goal was to remove a grandchild from the will. And I asked him if this was something his mother was willing to do. He said yes. He said he needed witnesses. And I said, yep, that sounds about right, because in Alabama, most wills require witnesses. And so he asked me to find and bring 2 witnesses, which I did. I invited 2 other Alabama notaries to go with me. And I did have a inkling that this may not go according to plan. And so before meeting with the family, I told the witnesses that the 3 of us, as impartial witnesses, needed to be very sure that the mother wasn't being forced or coerced. And I empowered both witnesses that if at any time they felt the signer was being forced, if I didn't speak up, they knew they could speak up to stop the notarization. And we met them in a public location. The mom was there. The son was there, as well as some additional family members. I ended up stopping the notarization because I held a lengthy conversation with the mother while the son was present and all of the family members. I asked her to tell me why I was hired. And she admitted it was to make changes to her will. I told her, I shared with the mother what the son told me, and I asked her, are you okay with removing this family member from your will? And she said no, which was not what the son told me. He then started having a conversation with her. trying to get her to change her mind. Now we're into coercion. I knew I'd be packing up my bags, but I waited just a little longer. And after the coercion came the force, because the son picked up a pen, placed it in his mother's hand, and said, "Just sign the form." And that's when I slapped the tabletop hard and said, "That's enough. It's clear to me that your mother does not want to remove this person from the will. We're leaving." I told the gentleman who hired me that if at that appointment I determined that the mother would not sign, that he still had to pay a travel fee to the witnesses. I chose not to be paid for that appointment, but I made sure the witnesses were paid a travel fee. But in that situation, I saw the signer being coerced, which is typically a little more subtle. Force is when someone is taking hold of the signer's hand, or demanding that they sign, or even threatening, "If you don't sign it, this will happen. Bad things will happen. You'll regret it later." All of that is unacceptable, and every notary should walk away from that type of notarization. And yes, I document that in my journal so that if at a later date it comes to light that the will was altered, and for some reason my name is on the document, I can demonstrate to authorities that I left that notarization and did not complete it. This is number 4 is very important. And so I believe those of you who are notaries for extended periods of time and are notarizing for the general public, you will find yourselves in situations like this. And it takes a certain amount of, I don't want to say courage, but firmness, good communication skills to be able to walk away in a way that is professional and forceful in a professional way. I'll never forget that appointment. And that wasn't the only example, but it was the one that came to mind. Moving on to number 5, a scenario or reason when a notary should refuse to notarize the signer's signature is when the signer is confused. Oh my goodness. Now I see this more than I see the being forced or coerced. And I just thought of something else, but I'll try to remember it later. But there will be times when notaries may be asked to go to the home of someone who is on hospice and is at the end stage of life, or notarize the signature for someone who is having some health issues. Perhaps they are under medication. Perhaps they're at early stages, Alzheimer's or dementia. Doesn't matter what's causing the confusion, but if the signer is not coherent thinking clearly, able to communicate with the notary must not sign. I don't even know if I want to share this example with you. I'm going to hold it. But I will say this. So how do you determine it? Most notaries are not medical professionals, correct? So the best way for you to ascertain the signer's state of mind is to hold a conversation, similar to what I did in the last example. I held a conversation. I asked the signer some basic questions. And so for confusion, I asked questions like, hi, I'm the notary. Your daughter, your son, your husband asked me to come and notarize your signature on some papers. Can you tell me what this paperwork is for? What do you plan to accomplish? Explain these documents to me. And I'm not looking for the signer to use big fancy words, but I'm looking for the signer to respond to my questions, look me in the eye, and tell me in their words the purpose of the documents. Keep asking questions. For power of attorney, if the document being signed is a power of attorney form, I'm asking the signer, so do you trust this individual? Are you telling me you want this person to be able to have access to your bank account, to your medical records, to decide with the doctors and nurses what your treatment will be? Is it your understanding, sir, that your grandson has your permission to decide when to sell your car, your home? I give examples based on what I see in the document. In addition to listening to the answers, I want the responses from the signer to be coherent, to make sense. If the signer is drifting off and talking about things that are irrelevant or happened some other time ago, if they're telling me they're seeing angels in the room right now, and I believe in angels, but for this moment, the angels should not be interfering with the notarization. If they are, that's all the more reason to stop the notarization. But in addition to focusing on what the signer is saying, I think it's important for notaries to observe body language. What is not being said? The tone of voice, arms. Does this person seem visibly upset, afraid, angry? And could it be related to them being confused or reluctant to sign the document? So hands down, if the signer cannot demonstrate to the notary that they understand what they are signing, the notarization should be stopped. Moving on to reason number 6. The notary cannot use their official seal unless the document includes a notary certificate that has been completed correctly or that can be completed correctly. So missing notary certificate. For those of you who haven't been trained, you may not even know what is meant by a notary certificate. A notary certificate is the section of the form that the notary completes that tells the notary the type of notarization to perform. This means if someone hands me a handwritten note on a sheet of paper, the only way I can notarize the person's signature on a sheet of paper is if they sign it and if a notary certificate has been added to that sheet of paper. Under no circumstance, I wish I had thought to bring in my notary bag. Under no situation should a notary use their seal, use their stamp, when a notary certificate is not present. It is an invalid notarization. Reason number 7, if the notary is unable to communicate with the signer. Now, lack of communication can stem from the signer's confused, the signer is unconscious, and it could be the signer speaks a different language from the notary. It is expected for the notary to be able to communicate with the signer so that the notary can ascertain, are you being forced or coerced? Do you understand what you're signing? There's got to be communication going on. Another example, I'm going to make this quick, always memorable for me. A couple invited me to a nursing home. Their family member was, I believe, at the end stage of life. Based on what I knew, this was a family that I was very familiar with. Before I even left home, I questioned the couple. I said, look, I've seen your family member on a regular basis. You sure I'll be able to speak with your family member, this person, and hold a yes, Michelle, yes. Oh, yes. They speak. I said, okay, will they be able to sign their name? Yes, yes. They may need a little help. I said, no. I said, they can't have help. I said, it's fine if the signature is illegible. It's fine if they make an X, but no, they can't be helped. Yep, no problem, no problem. Do I dare share the type of form it was? I guess that really doesn't matter. But when I arrived at the nursing home, the family member was in bed, eyes closed. I greeted the family member. The family member did not respond. Lying in bed, eyes closed. The family then started to speak. Wake up, Michelle is here to notarize your signature. I did see the eyes flutter a little bit, so I knew the family member was alive, but that's it. The form that needed to be signed was very important, extremely important. It was directly tied to the family being able to receive financial payments. And so I understood if this form does not get signed and notarized, payments, financial payments, would stop coming into the family. I made multiple attempts to speak with the family member that was a patient, and it just didn't happen. The eyes may have opened just briefly. I could tell the family member wasn't making eye contact with me, eye contact with anyone. And so I wasn't in that room for long. But before I left, I had a very firm, terse conversation with the couple and let them know I didn't appreciate being put in that situation, and reminded them that as a notary public, I felt that I was being asked to do something illegal, and I did not appreciate that very much. I didn't mince words. I mince words when I'm with individuals, signers, and family members who don't know better. The gentleman at the public place, reason number 4, I think it was, or 5, he knew better. We had talked about it on the phone. Reason number 7, the couple knew about it. We talked about it on the phone. In these situations, notaries must not be pressured, not bend the rules, not give in, stand firm. Because in this situation, the illegal act could have, and I believe would have been considered fraud. And you don't commit fraud against an insurance company or a financial institution. Grave circumstances. We're not just talking about being ethical or having good morals or doing the right thing. We're talking about fraud, serious business. Yeah, bad memories. That took me back. That number 7 triggered me, folks. But these are situations that will come up, which is why no one should take on the role of being a commissioned notary public unless you realize how difficult it can be. All right, let's move on and wrap this up. Reason number 8, if the notary doesn't understand the document, the notary shouldn't sign the form. And I'm sure I'll have a few of you who will disagree with this. And that's fine. I want to hear your reasons. But hear mine. If I don't have a basic understanding of a document, how can I be confident that the signer knows what they're signing? Remember, and I'm not saying I need to be a legal expert, but let me give you an example. The Alabama marriage certificate, all right? Looking at the form, other than the heading, most people don't really know that once they sign, I sign and notarize as a notary, they're not applying for a marriage license. They're getting married. This is a good example. And so when I notarize the Alabama marriage certificate, I ask them, what do you expect from this? If they're telling me, we're applying to get my marriage license, no, you are getting married. When the probate office receives this form that has been signed and notarized, Once they stamp it and hand it back, you're married as of today. So it's important that signers know that. Oh, okay, okay. And I've even had some couples say to me with the marriage certificate, oh no, we thought that was just step number 1 of 3 or 4 steps. So like, we can't be married today. We need to be married. Our marriage date needs to be October 1st. And so I'd say, then you need to wait and meet with me on October 1st. Okay, so again, I'm not asking or saying that notaries have to be familiar or knowledgeable about every form out there, but it is imperative for that you gain an understanding, and the way you do that is you're going to review the document before anybody brings out their pens. Scan the document, like, oh, okay, it's a bill of sale. That means something is being sold. And then ask questions. Okay, is this a car? Is this a boat? Is this an ATV? Okay, are you the seller? Are you the buyer? Okay, I've got a basic understanding, even though I've never owned a boat. Okay? So don't be afraid to ask questions, because by asking questions and listening to the answers, you will know whether you can proceed with the notarization or you cannot proceed. I've got plenty more examples that I could give you for this. We don't have time right now, so let's move on to reason number 9. A notary should not notarize a signature if the notary lacks knowledge and training. What do I mean by that? I'd say 90% of the documents that Alabama notaries will see require a venue to be on the notary certificate. And it is up to the notary to make sure that the venue is accurate. And if the notary does not know what a venue is, how to correct it if it's incorrect, the notary should notarize. Notary needs to be able to identify and correctly perform the different types of notarizations. Not all notarizations are alike. You're going to treat acknowledgments a little different from a jurat. You're going to treat a copy certification different from an oath or swearing someone into office. It is the notary's responsibility to know what notarization they're performing and how to perform each one. It's the notary's responsibility to make changes or corrections to the notary certificate. I know I mentioned the venue, but in addition to the venue, other wording in the body section of the certificate to make sure that it reflects exactly who the notary met with and the notarial act that the notary performed, and then information like the correct date, which is very important. And then finally, the notary needs to know how to correctly calculate the notary fee. One of the reasons why a notary may be slapped with misdemeanor or felony charges is if the notary is overcharging signers. If you have questions about these steps, let me know in the comments section. Guess what? We're almost done. Reason number 10 for refusing to notarize a signature when the notary suspects fraud. I already gave you an example of that. I probably can come up with more. I'm glad they don't happen too often. When someone knows they're doing wrong, when a signer, a family member knows what they're asking the notary to do is fraudulent. And by the way, notaries, now we can report situations when we are being asked by the public, someone in the public, to do something illegal. All right, suspicion of fraud. When the document contains fraudulent information, if the notary has reason to believe the transaction is fraudulent. Again, how are we going to know that if we don't review the document? And you compare what's in the document to what the signer is saying and acting. I'm going to leave it there for now. I may want to take up this topic in a fraud in another video, but I will say this. This video is being recorded in August 2024. I believe there's more incidents of fraud today involving notaries. Not saying, yeah, and sometimes it's the notaries, unfortunately. But whether it's the notaries or the signers, we're seeing more incidents of fraud taking place. And what I will say is the law that was passed in 2023 is addressing this very thing. And any notary in Alabama who has been performing fraudulent notarizations, deliberately ignoring notary laws, I hope you know about the changes in the laws, because law enforcement officers are actively investigating complaints and cases like some of the ones we talked about. And you've got to be careful out there whether you're doing it knowingly or unknowingly, which is why I feel more than ever before notary training is of the utmost importance. So before you use your notary seal, stamp, embosser, you need to get training. And you're not going to get the training you need by limiting what you learn to YouTube University. It's a great, YouTube is a great start and add-on to formal notary training, but you still need the classroom or online training where the focus is getting into the details, the specifics of our role. My suggestions to you is one, don't wait until it's time for you to renew your notary commission. You have access today to Alabama's mandatory notary training course. That's one of the changes that went into effect September 1, 2023. We all have to pass the training every 4 years. You can go to alpja.org today, search for the Notary Public Training, and go ahead and review that material. You can also download a free copy of Alabama's new notary laws by going to my website, trainalabama.com. You can also find a recording of a Zoom meeting that I hosted with Alabama Notaries back in 2023, where I reviewed the major law changes with notaries across the state. You'll also find that at trainalabama.com. If you're more of a reader than a listener, I do have an ebook out on Amazon and Kindle called Alabama's Notary Accountability Act of 2023. Please, please get informed about the new steps you need to take every time you use your notary seal. What I think. Not enough notaries understand just how important the notary's role is. Mistakes can be costly, and notaries are ultimately and financially responsible for those errors. Again, that's more true today than before. We have always been financially responsible for the mistakes that we make as notaries. That is why we are bonded, okay? And so when you make a mistake, if the signer or the customer suffers financial harm, they can collect money from your bond. But what many notaries don't realize is that the bond company then mails you the bill. We are required to reimburse the bond, the surety company, in full for whatever monies they pay out to the harmed parties. I'll do a separate video about how the Alabama, well, not just Alabama, but any notary bond works, and also how the notary E&O insurance works. I hope you found this information to be helpful. If you did, all the more reason for you to be subscribed to the Notaries for Alabama YouTube channel. If you want to show how helpful this particular video was, give it a like, leave a comment, and if there is a question that you would like me to answer in the future, I'll be happy to do that in another video. I'm going to link either here or there the video where I talk about Alabama's new notary laws to make it easy for you to connect with it. I hope you find that helpful. And again, I invite you to join me and 1,600 other notaries over in Facebook, Notaries for Alabama Hangout. And then finally, if you are interested in learning about Alabama's remote notarization law, please search for that channel, Alabama Remote Notarization, here on YouTube. Thank you for tuning in, and I look forward to seeing you in the next video.